We are currently looking at a 32-day Homeland Security shutdown. We have a multi-billion-dollar conflict involving Iran, demanding immediate congressional attention. And there is a massive fight brewing over the 2030 census. But if you look at the Senate floor today, the chamber is entirely paralyzed by a marathon debate over who gets to vote in the next election.
Welcome to Floor Notes. I'm Reed.
And I'm Paige. Since this is our full session episode, we have the time today to really pull apart the procedural mechanics, keeping the chamber at a standstill.
Grab a comfortable chair, because we are looking at the long game today. When there is a lengthy funding lapse and complex international issues stacking up, you might expect the schedule to be a flurry of emergency votes.
You would assume that, Reed. However, as anyone who has worked in the cloakroom knows, the calendar is dictated by majority priorities and the rules of debate. Today, we are going to map out the entire legislative landscape. We will examine the Homeland Security funding gap, dive into the proposed Iran resolutions, and trace the origins of this census dispute.
We are going to cover all of it. We will break down how committee jurisdictions are clashing and explain what these delays mean for the federal workers waiting on appropriations. It is a packed docket.
It certainly is, but everything is currently stuck behind one specific piece of legislation. It is eating up every available hour, and members are digging in for a traditional, continuous floor debate.
Which means we need to start exactly where the Senate is anchored right now. Let's get into the Save America Act showdown.
This piece of legislation, officially designated as S-1383, is the absolute center of gravity in Washington right now. The Senate advanced it earlier this week, on March 16, 2026, with a very narrow 51-48 procedural vote.
To give our listeners the exact whip count on that motion to proceed, it fell almost perfectly along party lines. Senator Tom Tillis, Republican of North Carolina, was absent. Senator Lisa Murkowski, Republican of Alaska, was the lone GOP defection, voting with the Democrats against advancing the measure.
And the fact that Majority Leader John Thune, Republican of South Dakota, forced this vote tells us exactly how important this is to the party's election year messaging. The Save America Act is President Donald Trump's top congressional priority. He has repeatedly taken to Truth Social to demand its immediate passage, explicitly linking it to Republican strategy for the 2026 midterms.
Let's unpack the mechanics of Title I of the bill, because it represents a massive shift in how Americans register to vote. Currently, under the National Voter Registration Act of 1993, often called the Motor Voter Law, you can register to vote by checking a box and signing a sworn attestation under penalty of perjury stating that you are a United States citizen.
The Save America Act completely overhauls that framework. It mandates documentary proof of citizenship for any new federal voter registration. An applicant would need to provide a U.S. passport or a combination of documents like a certified birth certificate alongside a government-issued photo ID. Driver's licenses alone would no longer be sufficient.
Furthermore, it requires states to actively remove non-citizens from their current voter rolls by running their registration databases through federal systems, primarily the Department of Homeland Security's SAVE system, which stands for Systematic Alien Verification for Entitlements.
Senator Mike Lee, Republican of Utah, is the primary champion of this legislation in the upper chamber. He delivered a very detailed floor speech outlining the core philosophy behind the bill, summarizing it with the mantra, "Make it easy to vote, but hard to cheat."
He tackled the constitutional arguments head-on. Democrats have argued that placing these documentation requirements on voters infringes on their fundamental rights. Senator Lee drew a direct comparison to the Second Amendment. I want to read a specific portion of his remarks from the congressional record.
Please do.
Lee said, quote, "The fact that something is a constitutionally protected right doesn't mean that it has to be uninhibited. Take, for example, the Second Amendment, the right to bear arms. Yes, we have a constitutionally protected right to bear arms, and it is a fundamental right that is available to individuals. Yet, when you decide to exercise that right By going into a federally licensed firearms dealer to purchase a firearm, guess what you have to do? You have to produce identification, and you have to wait a period of time.
He applied that same logic to everyday age verifications, noting that we do not allow people to simply sign a paper promising they are 21 when purchasing alcohol or tobacco. For Lee and his Republican colleagues, verifying citizenship with physical documents is a basic security measure that protects the value of a legal ballot.
Senator Lee also spent considerable time diving into the legal history that led to this moment. He specifically cited the 2013 Supreme Court case, Arizona v. Intertribal Council of Arizona. In that decision, the court ruled that the 1993 motor voter law preempted states from requiring additional proof of citizenship on federal registration forms. Lee argues that ruling created a vulnerability, especially amid recent high levels of immigration, because states now frequently issue driver's licenses to non-citizens.
Other Republicans echoed those concerns during the marathon session. Senator John Barrasso, Republican of Wyoming, argued that the Biden administration's border policies allowed millions of migrants to enter the country, creating a direct risk to electoral integrity. Barrasso pointed to polling data showing that upwards of 80% of Americans support photo ID requirements at the polls.
But the Democratic opposition is equally fierce, and their objections center entirely on the administrative burden this places on eligible, legal voters. Senator Chuck Schumer, Democrat of New York, delivered a combative speech promising to block the bill indefinitely.
Schumer framed the legislation as a calculated effort to suppress voter turnout ahead of the midterms. Let's look at his direct quote from the floor. Senate Democrats will hold the line as long as necessary, because with this bill, democracy is at stake. I want to be very clear. The SAVE Act is not about voter identification. It is about voter suppression.
The logistical warnings coming from Democrats and from independent election administrators are quite severe. The Brennan Center for Justice and various county officials estimate that approximately 21 million American citizens lack immediate access to passports or birth certificates. Procuring a new passport costs at least $165 and takes weeks to process.
Senator Maria Cantwell, Democrat of Washington, highlighted how these requirements would specifically impact women. She noted that roughly 69 million married women in the United States have changed their surnames. Under the Save America Act, if the name on your birth certificate does not match your current legal name, you must provide additional documentation, like a marriage certificate, or sign a specialized affidavit to register.
Cantwell also defended the current system's safeguards. In her home state of Washington, which conducts elections entirely by mail, voters sign a declaration on the ballot envelope under penalty of perjury. She brought a prop to the floor, holding up a ballot envelope to read the exact warning, emphasizing that falsely claiming citizenship carries a maximum imprisonment of 5 years or a $10,000 fine. She argued that the incidence of non-citizen voting is statistically minuscule, citing Heritage Foundation data showing a rate of 0.07%.
Senator Alex Padilla, Democrat of California, approached the bill from the perspective of state election officials. He pointed out that the legislation essentially bans online and mail-in voter registration by requiring voters to present their documentary proof in person to a local election office. He argued this creates immense hurdles for rural voters who live far from municipal buildings, students who attend college out of state, and seniors with mobility issues.
Padilla was also highly critical of the requirement to run state voter rolls through the DHS SAVE database. He pointed to reports indicating that the system, when tested by certain states, generated false positives, incorrectly flagging native-born U.S. citizens for removal. Democrats warn this will lead to massive erroneous voter purges on the eve of an election.
And the cost of implementation is another major factor. The National Association of Counties issued an alert estimating this would create a $510 million unfunded mandate for local jurisdictions. They would have to overhaul registration systems, retrain staff to verify complex citizenship documents, and manage the new in-person requirements.
All of those administrative details are crucial. However, the legislation currently on the floor has evolved significantly since it originally passed the House in February. Senate Republicans have introduced a sweeping substitute amendment that vastly expands the scope of the bill.
Yes, Senator Eric Schmitt, Republican of Missouri, introduced an amendment via Senator Thune that attaches two major new sections to the election provisions. Title II is named Save American Sports, and Title III is named Save American Children.
Title II amends the Education Amendments of 1972 to strictly prohibit biological males from participating in athletic programs designated for women and girls. Any recipient of federal funds that facilitate such participation would be in violation of the law.
Title III introduces severe federal criminal penalties. It establishes up to 10 years in prison for medical professionals who perform gender-affirming surgeries or provide hormone treatments, referred to in the text as chemical castration, to minors. The amendment includes narrow exceptions for physical disorders or genetic anomalies, but explicitly states that mental, behavioral, or emotional distress does not qualify as an exemption.
During his floor remarks, Senator Schmitt argued that these three titles belong together philosophically. He stated, "A republic requires citizens, truth, and the courage to defend both." He positioned the voting requirements as defending citizenship, the sports provisions as defending biological reality, and the medical restrictions as protecting children from irreversible harm.
Senator Barrasso echoed both sentiments, citing a United Nations report regarding female athletes losing medals and roster spots to transgender competitors. He framed the medical restrictions as common sense, comparing the maturity required to consent to life-altering surgeries to the maturity required to vote or purchase alcohol.
By attaching these highly polarizing cultural provisions to an already controversial election bill, Senate Republicans are guaranteeing a protracted standoff. They know that attaching restrictions on gender-affirming care makes the legislation completely unviable for any Democrat to support.
Which brings us to the underlying strategy here. Republicans currently hold a narrow 53-47 majority in the Senate. Advancing the bill required a simple majority, but actually passing it and overcoming a legislative filibuster requires 60 votes. The math simply does not exist for this bill to become law under current Senate rules.
Exactly. This marathon debate is a messaging vehicle. By holding the floor for days on end, Republicans like Mike Lee and Ted Cruz, Republican of Texas, are forcing Democrats to continually go on the record opposing voter ID and proof of citizenship, policies that poll very well nationally.
President Trump is watching this closely. He has threatened to veto other pending legislation unless the Senate acts on this package. It places immense pressure on vulnerable Democrats facing tough re-election campaigns in 2026, forcing them to navigate a bill that combines widely popular voter ID concepts with deeply contested social policies.
Meanwhile, the Democrats are equally resolved to hold the line. They view the entire exercise as political theater, designed to lay the groundwork for challenging future election results. Senator Patty Murray, Democrat of Washington, accused Republicans of trying to raise the cost of voting to compensate for unpopular policy platforms.
The floor dynamic is fascinating to watch. We saw Senator James Lankford, Republican of Oklahoma, give a detailed breakdown of his state's election procedures. He praised the system of paper ballots, optical scanners, and bipartisan poll workers, arguing that the Save America Act simply takes those state-level best practices and applies a uniform federal standard.
Right. And then you have Senator Chris Coons, Democrat of Delaware, pivoting the conversation entirely. He took the floor to express profound frustration that the Senate is debating election laws and cultural issues while military personnel are actively engaged in operations overseas.
That frustration over Senate priorities is a recurring theme. The prolonged debate over S. 1383 is consuming precious floor time. Every hour spent arguing over passport requirements and Title IX definitions is an hour not spent addressing the immediate fiscal deadlines bearing down on the federal government.
which is causing significant anxiety among federal workers and agency heads. Because while the political class focuses on the 2026 electorate, critical departments are operating without funding.
That is exactly where we need to direct our attention next. The standoff over election administration has completely sidelined the appropriations process, leaving key agencies in the dark. Up next, we will examine the ongoing fallout from the 32-day Homeland Security shutdown.
32 days. We are now entering the 5th week of a partial government shutdown that is entirely isolated to the Department of Homeland Security. Every other federal agency has been funded through the regular appropriations process. Congress completed 11 of the 12 required spending bills. DHS is completely alone on this island.
The population of that island is massive. We are looking at more than 100,000 federal employees currently working without pay. That encompasses the Transportation Security Administration, the Coast Guard, the Federal Emergency Management Agency, the Secret Service, and the Cybersecurity and Infrastructure Security Agency.
Let us clarify the mechanics of what working without pay actually entails in this context. Under the Anti-Deficiency Act, federal personnel deemed essential for the safety of human life or the protection of property are legally required to report for duty during a lapse in appropriations. Thanks to the Government Employee Fair Treatment Act, passed several years ago, these workers are guaranteed back pay once the shutdown ends. In the interim, however, those paychecks read $0. The financial obligations of these workers, mortgages, rent, groceries, do not pause.
Representative Tracy Mann, Republican of Kansas, took to the House floor to articulate the local and personal impacts of this national stalemate. He represents the Big First District, an area where aviation is a critical economic driver. Down the road from his district is Wichita, often referred to as the air capital of the world, where thousands of commercial aircraft are manufactured.
Aviation safety and logistics are deeply embedded in the economy of his state, so a disruption at the TSA is felt acutely.
Precisely. Representative Mann delivered a 5-minute address urging the Senate to act. I want to read a portion of his remarks. He stated, "National security should never be used as a political bargaining chip. These are hard-working Americans who show up every day to do their job, protect travelers, and secure our homeland, even while Washington politics leave them without the pay they have earned."
The operational strain Mann is describing is compounding daily. We are in the middle of the spring break travel season. Absenteeism among TSA officers is spiking. We have seen reports indicating that over 300 TSA agents have formally resigned since this lapse began in mid-February. At certain major hubs, like Houston Hobby, callouts have approached 50%. We are seeing security lines stretching out of the terminals and into airport parking garages.
In response to those visible disruptions, we are seeing attempts at procedural maneuvers to address the most public-facing symptoms of the shutdown. Earlier this week, a series of bills were read into the Senate record for the first time. One of them was Senate Bill 4127.
S-4127 is a targeted piece of legislation. It is a bill making continuing appropriations specifically for essential Transportation Security Administration pay and operations during the lapse that began on February 14, 2026.
This highlights a specific legislative strategy. Democratic leadership in the Senate has attempted to pass piecemeal funding for universally popular, less controversial components of DHS, such as the TSA, the Coast Guard, and FEMA.
It is a classic parliamentary pressure tactic. By offering a bill that only funds the TSA, Democrats force Republicans to go on the record objecting to paying airport security screeners. However, Senate Republicans are uniformly rejecting this piecemeal approach. They argue that parsing out agency funding sets a destructive precedent. If Congress agrees to fund the TSA and FEMA separately, it deliberately leaves immigration enforcement agencies, specifically Immigration and Customs Enforcement and Customs and Border Protection, completely unfunded.
Senator John Thune, Republican of South Dakota, delivered a very pointed floor speech addressing this exact dynamic. He criticized the Democratic proposal to selectively fund certain DHS agencies, framing it as an extreme measure rather than a compromise.
He took particular issue with the framing used by the opposition.
He did. Let me read from Senator Thune's remarks in the congressional record. He said, "The Democrat leader had the audacity to call this a moderate plan last week. When did defunding law enforcement become a mainstream position in this country?"
Thune also highlighted the lack of momentum in negotiations. He pointed out that it took Democrats 18 days to respond to the White House's latest policy offer, characterizing their eventual response as virtually identical to prior unworkable proposals. He contrasted the severe financial distress of federal workers with comments from Democratic leadership, quoting one senator who described the atmosphere as serene.
Thune summarized his frustration with this quote, "For Democrats, a government shutdown is just fine as long as it seems to be working for them politically, no matter whether it is hurting hard-working Americans."
To understand why Senate Democrats are willing to hold the line on this, even as the political pressure mounts and the travel disruptions dominate the evening news, we have to trace the timeline back to January. The core of this impasse has very little to do with the TSA or FEMA. It is entirely rooted in a fundamental rupture over immigration enforcement.
We need to discuss Operation Metro Surge.
Exactly. In January 2026, the federal government launched a massive, coordinated immigration enforcement initiative in Minneapolis, Minnesota. The operation involved deploying thousands of ICE and Border Patrol agents to the metropolitan area.
The deployment was highly aggressive. The resulting local disruptions were severe, including shuttered businesses and widespread protests. The flashpoint, however, was the deaths of 2 United States citizens during the operation.
Renee Nicole Good and Alex Jeffrey Preddy.
Yes, Renee Nicole Good was a poet and a mother. She was shot and killed by an ICE agent on January 7th while sitting in her vehicle. Alex Jeffrey Preddy was a 37-year-old Marine Corps veteran and a VA intensive care nurse. He was shot multiple times by Customs and Border Protection officers on January 24th during a period of local protests.
The fallout from those 2 incidents completely paralyzed the DHS appropriations process. House Republicans did pass full-year funding legislation, H.R. 7744, in early March, by a vote of 221 to 209. That bill included some bipartisan reforms that had been negotiated prior to the surge, such as increased funding for body cameras and de-escalation training.
Senate Democrats argue that body cameras are profoundly insufficient following the events of Metro Surge. They are demanding comprehensive structural policy changes. Their requirements include prohibitions on ICE operations near sensitive locations like schools, and strict mandates for judicial warrants prior to home entries. They have effectively blockaded the House-passed funding bills, demanding accountability for the Minneapolis operation before agreeing to a full department budget.
This deeply entrenched conflict is producing fascinating procedural entries in the congressional record. For instance, we saw the introduction of Senate Amendment 4439.
That amendment was introduced by Senator Ruben Gallego, Democrat of Arizona.
Senator Gallego submitted this amendment to Senate Bill 1383. Nominally, S. 1383 is legislation aimed at establishing a Veterans Advisory Committee on Equal Access. The amendment itself utilizes a mechanism known as a sense of Congress provision.
Let me read the exact text of Senator Gallego's amendment. It is the sense of Congress that former Minneapolis residents Alex Jeffrey Preddy and Renee Nicole Good, who were both killed by federal immigration enforcement officers in January 2026 during Operation Metro Surge, were not domestic terrorists.
There is a very specific reason Senator Gallego attached this language to a Veterans Affairs bill. Alex Preddy was a Marine Corps veteran. A sense of Congress resolution does not create new law, appropriate funds, or alter federal statutes. It operates as a formal declaration of the legislative branch's opinion or intent.
Structurally, this amendment was ordered to lie on the table. In parliamentary terms, That means the text was introduced and placed on the legislative calendar, but it was not actively debated or scheduled for an immediate vote.
By filing the amendment, Senator Gallego is utilizing the official record to aggressively counter narratives surrounding the operation and to officially memorialize the two individuals. It is a calculated use of procedure to plant a flag in the historical record. It ensures their names and the assertion that they were not domestic terrorists are permanently logged in the archives of the Senate.
While Congress remains deadlocked over the policy implications and the human toll of Operation Metro Surge, the operational realities of the shutdown are colliding with a highly volatile global threat environment. The agencies responsible for mitigating external threats are operating at a severe disadvantage.
The procedural stalemate has morphed into a tangible vulnerability. During his floor speech, Senator Thune outlined several immediate concerns regarding the current threat matrix.
He noted that a medical tech company called Stryker was the victim of an Iran-linked cyber attack earlier in the month.
Simultaneously, the Cybersecurity and Infrastructure Security Agency, the primary federal entity tasked with defending domestic networks against state-sponsored intrusions, currently has critical personnel out on furlough due to the lapse in appropriations.
Senator Thune also referenced domestic incidents. He highlighted individuals with alleged ties to ISIS attempting to target public officials in New York, and another violent attack in the Detroit area linked to suspected Hezbollah connections.
We are witnessing the degradation of emergency response capabilities across multiple fronts. FEMA has been forced to cancel specialized training programs for state and local first responders. Furthermore, the agency's disaster relief fund is dwindling rapidly, currently hovering around the $5 billion mark.
The Coast Guard is experiencing severe disruptions to mandatory maintenance and training operations. Those delays directly impact their readiness and deployment capabilities in international maritime hotspots like Bahrain.
This creates a uniquely complex dynamic for lawmakers on both sides of the aisle. House Republicans are pointing to the heightened global alerts, particularly the cyber threats and domestic terror probes, demanding the Senate pass the comprehensive funding bill immediately to secure the homeland. Senate Democrats are pointing to the fatal outcomes in Minneapolis, demanding targeted accountability measures before authorizing a budget for the agencies involved.
Caught between those two immovable positions are over 100,000 federal workers who are navigating empty bank accounts, alongside millions of Americans facing disrupted travel and degraded federal emergency services.
The White House recently sent a letter offering several DHS policy modifications in an attempt to bridge the gap. That correspondence marks the first public detail of negotiations in months. However, opposition leadership largely dismissed those proposals as unserious, and there are currently no high-level summit meetings scheduled between the administration and Senate leadership to break the logjam.
The ripple effects of this domestic legislative failure are extending far beyond our borders. The vulnerabilities in our ports, airports, and cyber networks are occurring precisely as international tensions escalate to dangerous new levels.
The intersection of domestic gridlock and international conflict requires careful examination. The operational gaps at Homeland Security are particularly concerning given the rapidly deteriorating situation overseas.
We will pivot our focus to that exact dynamic. Coming up, we will examine the recent military escalation in Iran and the mounting costs associated with this expanding conflict.
Operation Epic Fury is currently entering its third week. When the executive branch initiated this joint operation with Israel, the prevailing projection communicated to lawmakers was that the conflict would be resolved in a matter of days. The reality on the ground has diverged substantially from those initial estimates.
That divergence was the central focus on both the House and Senate floors this week. As the deployment extends, the human cost is coming into sharp relief. We are seeing a steady increase in casualties, and members of Congress are fulfilling the solemn duty of memorializing fallen service members in the congressional record.
It is a procedural function, yet it carries immense historical weight. The congressional record serves as the official, permanent diary of the United States government. When a representative or senator reads a service member's name during a floor speech, they are ensuring that individual's sacrifice is officially documented in the National Archives.
On the House side, Representative Terry Sewell, a Democrat from Alabama, delivered a tribute to 6 Air Force personnel who died on March 12, 2026. They were the crew of a KC-135 Stratotanker refueling aircraft that crashed in western Iraq during a combat mission supporting operations in Iran.
The details surrounding that crash illustrate the logistical hazards of the current engagement. According to U.S. Central Command, the incident involved 2 aircraft in what was designated as friendly airspace. The second plane managed to land safely in Israel, but the KC-135 was lost. The military confirmed the crash was not due to hostile or friendly fire, though a comprehensive investigation remains open.
Representative Sewell used her 5 minutes of allotted floor time to focus on 3 of the airmen based in her district, at the 99th Air Refueling Squadron in Birmingham. She detailed the life of Major John Alex Klinner, a 33-year-old decorated officer and father of 3, Captain Ariana Savino, 31, who was recognized for her efforts to support Latin women in aviation, and Technical Sergeant Ashley Pruitt, a 34-year-old mother from Kentucky, who served as an assistant flight chief.
She also ensured the names of the other 3 crew members, Captain Seth Koval, Captain Curtis Angst, and Technical Sergeant Tyler Simmons, were formally recorded. Following standard military protocol, the fallen airmen will be returned to the United States through a dignified transfer ceremony at Dover Air Force Base, while the Defense Department coordinates counseling services for affected personnel and their families.
Representative Sewell concluded her address with this statement: "I rise today to honor 6 heroic Americans who made the ultimate sacrifice and gave their lives in defense of the United States. On behalf of Alabama's 7th Congressional District and a grateful nation, I ask my colleagues to join me in remembering the lives of 6 airmen who paid the ultimate price."
That incident brings the publicly acknowledged U.S. death toll for Operation Epic Fury to at least 13 service members. It marks the 4th U.S. aircraft lost since the conflict began, following the downing of 3 F-15E fighter jets by friendly Kuwaiti fire a few days prior. The airspace in the region is highly congested, and the operational tempo is pushing equipment and personnel to maximum capacity.
The Senate engaged in a similar procedural memorial. Senators Amy Klobuchar and Tina Smith, both Democrats from Minnesota, submitted Senate Resolution 648. This document formally honors Master Sergeant Nicole M. Amor, who was killed in an unmanned aircraft system attack on Port Shuaibah in Kuwait on March 1, 2026.
Master Sergeant Amor was serving with the Army Reserve's 103rd Sustainment Command. She had a nearly 20-year military career, including previous deployments to Kuwait and Iraq in 2019, and she was only days away from returning home. The drone strike claimed her life alongside 5 other service members: Captain Cody Cork, Sergeant First Class Noah Teachins, Sergeant Declan Cody, Major Jeffrey O'Brien, and Chief Warrant Officer 3, Robert Marzan.
The resolution outlines her extensive list of decorations and notes her posthumous promotion from Sergeant First Class. The text explicitly states that the Senate, quote, extends its sympathies, gratitude, and support to the family of Master Sergeant Amor and to all others affected by the attack at Port Shuaibah, Kuwait. Back in Minnesota, Governor Tim Walz ordered flags to fly at half-staff until her interment, and her community in White Bear Lake is actively working to establish a permanent memorial.
These somber tributes stand in stark contrast to the intense procedural maneuvering happening in the committee rooms. The administration is executing this military campaign without formal congressional authorization. There is no declaration of war, nor is there a specific authorization for use of military force, commonly known as an AUMF, for Operation Epic Fury.
The executive branch maintains broad authority under Article 2 of the Constitution to direct military action to protect national interests. Congress, however, holds the power to declare war and controls the federal purse under Article 1. This fundamental division of constitutional authority is creating a massive friction point between the two branches.
Senate Democrats are applying maximum leverage to that friction point. They are demanding that Secretary of Defense Pete Hegseth and Secretary of State Marco Rubio appear before the relevant committees for public sworn testimony regarding the overarching strategy.
The distinction between a classified briefing and public sworn testimony represents the core of this institutional dispute. Administrations historically prefer classified briefings, frequently limiting them to the Gang of Eight, the top congressional leaders from both parties and the heads of the intelligence committees. The standard argument is that this setting allows for candid discussions regarding military intelligence without compromising operational security.
Lawmakers outside that specific circle argue that relying solely on the Gang of Eight leaves the American public entirely in the dark. Sworn public testimony forces administration officials to articulate the broader strategy on the record, under the penalty of perjury. Senators want Hegseth and Rubio to answer highly specific questions regarding the exact objectives, the plan to reopen the Strait of Hormuz, and the parameters of an exit strategy.
Looking at the floor speeches this week provides a clear picture of the growing skepticism regarding the administration's initial planning. One Senate Democrat delivered a highly critical address, pointing to the administration's apparent surprise regarding Iran's retaliatory strikes against neighboring countries.
The senator highlighted the administration's own admission of shock regarding strikes on Saudi Arabia, Qatar, the UAE, and Kuwait. The critique leaned heavily on the principle of basic accountability, arguing that a failure to anticipate retaliation indicates a severe lack of preparation.
I have an excerpt from that floor speech. The senator stated, "If you break it, you buy it. Well, Donald Trump, you broke it badly, and now you are trying to get out of paying the price." The speech goes on to note the closure of the Strait of Hormuz, rising oil prices, and the estimated 200 troops injured so far. It concludes with a direct procedural demand. We need to hear from Secretary Rubio, Secretary Hegseth, and others under oath.
To force the scheduling of those hearings, Democrats are utilizing War Powers resolutions. The War Powers Act of 1973 was passed in the aftermath of the Vietnam War, specifically to reassert congressional authority over military deployments. Under the Act, certain resolutions demanding the removal of unauthorized forces are granted privileged status.
A privileged resolution bypasses the standard committee process and guarantees a floor vote. While an initial War Powers vote failed last week, the threat of forcing repeated high-profile votes on the conflict creates a difficult scenario for Republican leadership. They have to continually marshal their caucus to defend an increasingly complex military engagement.
Which brings us directly to the financial component. Sustained military operations require enormous capital, and the price tag for Operation Epic Fury is generating severe domestic blowback. The administration reported expending $11.3 billion during the first 6 days of the conflict.
That $11.3 billion figure quickly became a focal point in the House. Representative Kelly Morrison, a Democrat from Minnesota, delivered a 1-minute speech that explicitly linked the cost of the overseas conflict to domestic economic struggles.
1-minute speeches are a daily staple of the House schedule. Before the formal legislative business commences, members can request 60 seconds to address the chamber on any topic of their choosing. They are frequently used to distill complex policy disputes into highly digestible arguments intended for public consumption and constituent outreach.
Representative Morrison utilized her time to contrast the military expenditure with the rising cost of healthcare and housing. Here is the key section of her address. The same week, we learned that the Trump administration spent more than $11.3 billion on the first 6 days of the war in Iran alone. A survey found that 1 in 3 Americans are skipping meals, rationing medications, and delaying buying a home or having children because of the cost of healthcare in this country.
This represents a classic guns versus butter argument. It frames federal spending as a zero-sum game, suggesting that dollars allocated for munitions and deployments are directly subtracted from domestic welfare programs. Morrison is making the case that as the wealthiest nation on Earth, the United States possesses the resources to ensure baseline affordability for its citizens, but those resources are being misallocated toward foreign interventions.
She closed her remarks by stating, "The people deserve a Congress who will fight for them," explicitly characterizing the current spending priorities as a betrayal by congressional leadership.
That specific dynamic will shape the upcoming appropriations battles. The Department of Defense will inevitably require supplemental funding to maintain the operational tempo in Iran. The initial $11.3 billion is merely the vanguard of the total cost. When the administration formally submits that supplemental package, every member of Congress will be forced to go on the record regarding the conflict.
Supplemental funding requests circumvent regular budget caps because they are designated as emergency spending. Historically, they pass with relative ease because opposing funding for troops in the field carries heavy political risks. Given the lack of an AUMF and the intense debate over the operation's objectives, however, a supplemental bill for Operation Epic Fury will face an intense gauntlet of amendments.
Lawmakers who oppose the conflict will utilize the supplemental request to introduce amendments aimed at curtailing the executive branch's military authority. We can expect proposals prohibiting the deployment of ground troops or restricting funds from being used to expand the conflict beyond Iranian territory. The administration will likely counter by arguing that any delay in funding directly endangers the personnel currently deployed in the region.
The closure of the Strait of Hormuz adds a massive global economic layer to this equation. Approximately 1/5 of the world's daily oil consumption passes through that narrow waterway. The disruption is actively impacting global energy markets, and a prolonged closure will hit the domestic economy through inflation and higher gas prices.
Which circles right back to Representative Morrison's concerns about the domestic cost of living. The intersection of international conflict and domestic affordability will be a defining theme for the remainder of this session. If there are no signs of regime collapse or a clear diplomatic off-ramp, the pressure to secure public hearings with Secretaries Hegseth and Rubio will become overwhelming.
We will continue to monitor the War Powers resolutions and track any supplemental funding requests as they emerge from the committees.
The debate over executive power and congressional oversight is about to shift to a completely different front.
Right. When we return, we will look at a piece of legislation rapidly gaining traction in the House, focusing on the effort toward federalizing the ban on gender-affirming care. Welcome back. Before the break, we mentioned a legislative push that represents a significant shift in domestic policy. We are looking at the effort to establish a nationwide ban on gender-affirming care for minors.
Up until recently, this debate has played out almost entirely at the state level. We've seen various state legislatures pass restrictions, followed immediately by challenges in federal court. Some laws have been upheld, others enjoined. What we are examining today is a coordinated effort to supersede that state-by-state patchwork with comprehensive federal law.
The mechanism for this push comes in the form of two proposed amendments to Senate Bill 1383. Originally, S. 1383 was drafted to establish a Veterans Advisory Committee on equal access.
Attaching major policy overhauls to unrelated committee bills is a familiar legislative tactic. It bypasses the usual committee markup process for the new language. In this case, Senator Marsha Blackburn, a Republican from Tennessee, along with Senator Tommy Tuberville, a Republican from Alabama, have submitted two sweeping amendments that would entirely replace the original text of the Veterans Bill.
We will examine both proposals, looking directly at the text of Senate Amendment 4457, titled the Chloe Cole Act. The focus is heavily on establishing civil liability. It explicitly prohibits what it calls covered interventions for anyone under 18 years of age.
The text defines these interventions as the use of puberty blockers, cross-sex hormones, and surgical procedures intended to alter physical characteristics to no longer correspond to an individual's biological sex. To understand the enforcement mechanism, we need to analyze how the bill creates a private right of action.
I will read the specific language from the congressional record. Quote, "An individual subjected as a child to a covered intervention prohibited by Section 303 may bring a civil action in an appropriate district court of the United States for damages."
The timeline attached to that civil action is particularly expansive. The statute of limitations extends for 25 years after the individual's 18th birthday. There is also a secondary trigger. A plaintiff can file within 4 years from the time the cost of a detransition treatment is incurred, whichever date is later.
The legislation specifically defines detransition treatment as any medical intervention or surgery that stops, reverses, or aids in the recovery from the effects of a prior covered intervention.
By tying the limitation period to the cost of detransition, the bill essentially creates a rolling window for liability. If an individual decides to reverse a procedure at age 40, the provider who performed the initial intervention when the patient was a minor could suddenly become liable to a civil suit decades after the fact.
The liability standards for medical providers are exceptionally stringent. The text states, "No liability for a healthcare professional under these provisions may be waived." It goes on to establish strict liability, meaning providers would be responsible for compensatory, non-economic, and punitive damages.
Strict liability is a substantial departure from standard medical malpractice law. Typically, a plaintiff has to prove negligence, that the doctor deviated from the standard of care. Under strict liability, the simple act of performing the procedure, if proven by clear and convincing evidence, is enough to hold the provider liable. The burden of proof completely shifts.
The amendment also includes a highly specific rule of construction regarding medical standards. It dictates that if a procedure occurred before this act passes, courts should give limited deference to prevailing standards of care if those standards contradict the intent of the act, provided the professional knew or should have known those standards were in scientific dispute.
That is a direct legislative instruction to the judiciary on how to weigh expert medical testimony. Congress is effectively stating that professional medical consensus cannot shield a provider from liability if the federal government determines that consensus was flawed.
To apply these rules nationwide, the authors rely on the Interstate Commerce Clause. Section 303 details exactly how federal jurisdiction is triggered.
Congress has historically used the Commerce Clause to assert authority over areas typically reserved for the states. If you read through these specific triggers, they cover almost every conceivable aspect of modern medical practice. The prohibition applies if the patient or the provider traveled in interstate commerce. It applies if any instrument, item, or substance used in the procedure crossed state lines.
It also applies to communications. If a clinic sends an email, makes a phone call, or processes a payment across state lines, which includes virtually all credit card processing or insurance billing, the federal law takes effect.
The practical reality of the American healthcare system is that no clinic operates entirely within the borders of a single state. Medical supplies are shipped nationally. Electronic health records are stored on servers located across the country. By tying the prohibition to the everyday tools of commerce, the legislation overrides states that have explicitly protected access to these treatments. A provider in a protective state could face federal liability simply because the medications they prescribe were manufactured out of state.
Moving to the second proposal submitted by Senators Blackburn and Tuberville, Senate Amendment 4425 takes the federalization effort a step further by introducing criminal penalties.
While the First Amendment relies on the threat of civil lawsuits to alter medical practices, Amendment 4425 proposes amending Title 18 of the United States Code to create federal crimes.
The text categorizes the prohibited procedures as genital and bodily mutilation and chemical castration. The penalties for knowingly performing or attempting to perform these procedures on a minor include fines and up to 10 years in federal prison.
The criminal amendment includes a strict definition of medical necessity. There are narrow exemptions built into the text for treating certain verifiable disorders of sexual development, precocious puberty, or acute physical injuries. However, it explicitly prohibits using psychological well-being as a justification for these procedures.
The congressional record states, for the purposes of subparagraph A, the health of a minor does not include I. Mental, behavioral, or emotional distress, or 2. A mental, behavioral, or emotional disorder.
That clause directly targets the primary medical rationale used by providers of gender-affirming care, which is treating gender dysphoria. By defining health exclusively in physical, biological terms, the legislation removes any legal defense rooted in mental health or emotional well-being.
Furthermore, the amendment codifies a specific definition of sex at the federal level. The text reads, "The term sex means the immutable biological classification of an individual as either male or female."
Establishing this legal definition across the federal code creates a firm baseline for determining what constitutes a prohibited procedure. It removes any ambiguity regarding how the federal government categorizes patients under this law.
These proposals are gathering considerable momentum outside the Senate chamber. We are seeing active public coordination with the executive branch. The Department of Justice officially transmitted the framework for the Chloe Cole Act to Congress, accompanied by a strong endorsement from Attorney General Pam Bondi.
Having the Department of Justice draft and transmit legislation is a clear signal of executive priority. It provides the effort with the full institutional weight and legal expertise of the DOJ. They are signaling an intent to aggressively defend this framework in court if it passes.
In the lower chamber, Representative Robert Onder, a Republican from Missouri, reintroduced the companion legislation on February 23, 2026, known as H.R. 7651. The House version has rapidly accumulated co-sponsors and currently sits with the Judiciary Committee.
Representative Onder's version mirrors the Senate amendments closely. It includes the same non-waivable liability provisions and an identical severability clause. The authors fully anticipate legal challenges and have structured the text to survive piecemeal invalidation by the courts.
The implications for medical providers are profound. A doctor in a state with legal protections for gender-affirming care would suddenly face a landscape where providing that care carries the risk of a decade in federal prison and a 25-year window for crippling civil lawsuits.
The conflict between state laws protecting these procedures and a federal mandate criminalizing them will create immediate, high-stakes constitutional questions regarding federalism and state sovereignty.
We will track the progress of these amendments and H.R. 7651 as they move through their respective chambers. Following a short break, we are turning our attention to a very different kind of legal battle, taking shape on Capitol Hill. We will examine the emerging fight over the Judgment Fund, specifically regarding its application to individuals involved in the events of January 6th. To fully grasp the stakes of this emerging fight, we need to unpack the mechanics of the Judgment Fund itself. For most of American history, if you sued the federal government and won, getting your money was a completely separate legislative hurdle. Exactly. Congress had to pass a specific individualized appropriation to pay you. If your postal truck got hit by a federal vehicle, your member of Congress might literally have to introduce a bill to get you your $500.
You can imagine how inefficient that became as the federal government expanded. So in 1956, Congress created the Judgment Fund. It is a permanent, indefinite appropriation administered by the Treasury Department. It exists to pay out court judgments and Justice Department compromise settlements when no other specific funding source is available.
It operates quietly in the background of the federal government. Most Americans never hear about it. But currently, the Judgment Fund is at the center of a profound separation of powers dispute involving the executive branch, the Justice Department, and the legacy of January 6, 2021. The primary catalyst for this legislative response is President Donald Trump's demand for $230 million in personal financial compensation. This claim is filed under the Federal Tort Claims Act, or FTCA.
The FTCA is a statute that provides a limited waiver of the federal government's sovereign immunity. Historically, the prevailing legal doctrine was the king can do no wrong, meaning you could not sue the sovereign. The FTCA allows private citizens to sue the United States for torts committed by federal employees acting within the scope of their employment.
President Trump filed administrative complaints seeking damages related to the previous Federal Bureau of Investigation and special counsel probes into his conduct during the 2016 election and his handling of classified documents. He argues his rights were violated and that the Justice Department owes him compensation. The Federal Tort Claims Act was designed for clear-cut cases of government negligence. A postal worker causing a traffic accident, or a slip and fall at a Veterans Affairs hospital. Applying it to the president's claim regarding past investigative actions by the FBI ventures into highly unusual legal territory.
It certainly does, especially because the FTCA typically includes a discretionary function exception. This provision shields the government from liability for decisions made by federal employees exercising their policy judgment, such as investigative or prosecutorial decisions.
That legal nuance brings us to the procedural reality of the claim, which prompted Senator Jackie Rosen, a Democrat from Nevada, to introduce Senate Amendment 4454. Her amendment is drafted as a sense of Congress resolution, and the text explicitly targets the internal dynamics of the Justice Department reviewing the president's claim. The conflict of interest is the central issue here. You have a sitting president seeking a massive personal payout from the very executive branch department he oversees. The officials evaluating the validity of that $230 million claim are appointees or employees within his own administration. Senator Rosen's amendment documents a timeline of personnel changes at the Justice Department that her office argues compromises the review process. The text notes that in January 2025, the DOJ removed Associate Deputy Attorney General Bradley Weinsheimer, who served as the senior career ethics official. The amendment also points to the March 2025 firing of Jeffrey Ragsdale, the director of the Office of Professional Responsibility, and the July 2025 firing of Joseph Tyrrell, who directed the Departmental Ethics Office.
By formally entering this timeline into the congressional record, Democratic lawmakers are building a legislative case that the internal guardrails for ethical review have been dismantled. The text of Senator Rosen's amendment concludes with a very direct statement. It reads, "It is the sense of Congress that Congress condemns in the strongest possible terms the calls by President Donald Trump for the Department of Justice to pay him $230 million.
The resolution failed to advance after Republicans, including Senator Rick Scott of Florida, objected on the floor. They characterized the measure as political theater during a period of fiscal instability. However, that failed amendment laid the groundwork for a more binding legislative effort. We are now seeing the introduction of the No Torts for Trump Act. Yes, Senate Bill 4124. This is a standalone bill explicitly prohibiting funds made available to the Justice Department from being used to make a personal payment to the president under the FTCA, either as a settlement or a payment from the Judgment Fund.
That marks a shift from expressing disapproval to attempting a statutory blockade. And while the fight over the $230 million plays out, another parallel battle regarding the Judgment Fund is escalating. This one involves the individuals prosecuted for the attack on the Capitol on January 6th.
Following his inauguration, President Trump issued blanket pardons for the individuals convicted in connection with the Capitol riot. That executive action triggered a complex legal chain reaction regarding court-ordered restitution. When someone is convicted of a federal crime, the judge often orders them to pay restitution. For the January 6th defendants, those payments were largely meant to compensate for the estimated $3 million in damage done to the Capitol building. Through the prosecution process, the government collected roughly $400,000 in restitution.
However, because the president issued pardons while many of these cases were still in the appeals process, the convictions are legally considered vacated. Consequently, federal prosecutors under the current Justice Department are arguing that the collected restitution must be refunded to the pardoned individuals.
In fact, a federal judge recently ordered the government to refund restitution to at least one individual whose case was vacated following the pardons. In response, Senator Alex Padilla, a Democrat from California, and Senator Sheldon Whitehouse, a Democrat from Rhode Island, submitted Senate Amendment 4450. The amendment is titled No Rewards for January 6 Rioters.
This legislation applies a very aggressive use of the appropriations power to override the judicial refunds. The text mandates that no funds shall be disbursed from the United States Treasury to refund any court-ordered compensation paid by anyone convicted for involvement in the attack on January 6th.
The amendment addresses the $400,000 already collected with a specific statutory directive. Quoting directly from the legislative text, the Secretary of the Treasury shall transfer any amounts described in paragraph 1 to the architect of the Capitol. The authors designed a precise mechanism for these funds. The legislation directs the Treasury Secretary to transfer the collected restitution away from the General Treasury and directly into the budget of the architect of the Capitol.
The architect is the federal agency responsible for the maintenance, operation, and preservation of the Capitol complex. By redirecting the funds there, the bill connects the financial penalties of the rioters directly to the physical repair of the building they breached.
It is important to distinguish between the two pots of money being discussed regarding January 6th. The $400,000 addressed by Senator Padilla's amendment is restitution. This is money the defendants already paid out of their own pockets as a penalty for their actions. The Justice Department is currently facilitating the return of those personal funds. Senators Whitehouse and Padilla also introduced a companion measure, Senate Amendment 4451, cited as the No Settlements for January 6th Law Enforcement Assaulters Act. This companion measure addresses a completely different financial mechanism.
Right. Following the pardons, several individuals involved in the Capitol attack began filing their own FTCA lawsuits, seeking damages for alleged harm suffered during the events of January 6th or during their subsequent prosecutions.
We have already seen the Justice Department approve a $5 million settlement for the family of Ashley Babbitt, who was killed during the breach of the Capitol. Democratic lawmakers anticipate a wave of similar settlements being approved by the current DOJ and paid out through the Judgment Fund. These legal settlements represent new taxpayer dollars flowing outward to compensate these individuals for alleged constitutional or physical harms. Both the restitution refunds and the FTCA settlements result in financial benefits for the pardoned individuals, but they draw on entirely different accounting ledgers.
Amendment 4451 defines a covered individual as anyone convicted of an offense involving assaulting a law enforcement officer in connection with the Capitol breach. It strictly prohibits the obligation or expenditure of any federal funds, specifically naming the Judgment Fund, for any legal settlement to these individuals.
The legislative maneuvering around these bills provides a fascinating look at Senate procedure. On March 17, 2026, Senate Majority Leader Chuck Schumer, a Democrat from New York, brought the No Torts for Trump Act to the floor along with 3 other related bills. The Majority Leader utilized a specific parliamentary tool to bypass the traditional committee process. He asked for the bills to receive their first reading en bloc. According to the congressional record, Leader Schumer stated, "I understand that there are 4 bills at the desk, and I ask for their first reading en bloc."
The presiding officer granted the request, and the clerk read the titles of the 4 bills. Reading bills en bloc simply means handling them together as a single group to save time. In the Senate, a bill must be read 3 times before it can be passed. The first reading is the formal introduction. Usually, a bill is then referred to the relevant committee for markup and debate.
But Leader Schumer did not want these bills sent to committee. Immediately after the clerk finished the first reading, he requested a second reading. Then, in the same breath, he said, "I now ask for a second reading, and I object to my own request, all en bloc." Objecting to your own request sounds counterintuitive, but it is a classic application of Senate Rule XIV. Under the rules, if there is an objection to a bill receiving its second reading on the same day it is introduced, the measure must be held over until the next legislative day.
When that next legislative day arrives, the bill receives its second reading. But because it was delayed by an objection, it bypasses the committee referral entirely and is placed directly on the Senate calendar of general orders.
It places the legislation in a holding pattern on the calendar. The majority leader can then call it up for a floor vote at his discretion, without waiting for a committee chairman to hold hearings or report the bill out. This procedural shortcut underscores the urgency Democratic leadership is placing on the judgment fund issue. They are positioning these bills for rapid deployment, anticipating further developments regarding the president's $230 million claim or additional Justice Department settlements for pardoned individuals.
The entire arc of these legislative efforts highlights a fundamental constitutional friction. Congress controls the power of the purse. The executive branch manages the administrative claims and the Justice Department's legal strategy. When those two branches hold diametrically opposed views on who deserves federal compensation, the judgment fund becomes a primary battlefield.
The outcome of this standoff will set lasting precedents regarding executive branch self-dealing, the finality of pardons, and the limits of congressional oversight over the federal treasury. We will continue to track S-4124 and the related amendments as the fiscal year 2026 appropriations deadlines approach.
Coming up next, we turn our focus to the international stage. We will explore the complex policy debate surrounding sanctions relief amidst the latest wave of global oil shocks.
The core of this debate centers on a series of decisions made by the Treasury Department in early March 2026. Global energy markets were experiencing severe turbulence, primarily driven by military actions involving the United States and Iran.
Right. The geopolitical situation escalated rapidly following the U.S. strikes on Iran in late February 2026. Those strikes led to reciprocal actions across the region, which disrupted commercial shipping routes, especially near the Strait of Hormuz. Consequently, oil prices spiked, pushing past $110 a barrel and driving domestic gas prices up nearly 20%.
Faced with those rising costs, the administration initiated a specific regulatory mechanism to increase global supply. On March 5, 2026, and again on March 12, the Treasury Department's Office of Foreign Assets Control, known as OFAC, issued temporary general licenses.
These are General Licenses 133 and 134. Essentially, they granted a 30-day window for certain transactions involving Russian crude oil and petroleum products, particularly those loaded onto vessels for delivery to India.
India is currently the second largest importer of Russian oil. Prior to these licenses, buyers were subject to strict international sanctions, including the G7 price caps, implemented after the 2022 invasion of Ukraine.
The administration's stated rationale for issuing the waivers is market stabilization. By temporarily allowing this Russian crude to flow through India's refining sector, the executive branch aimed to prevent a further shortage in the global petroleum supply.
That decision triggered an immediate response in the Senate, led primarily by Senator Ruben Gallego, a Democrat from Arizona. He filed 3 separate amendments targeting these specific OFAC licenses, attaching them to Senate Bill 1383.
Senate Bill 1383 was originally drafted to establish the Veterans Advisory Committee on Equal Access. Using it as the host for foreign policy amendments demonstrates how lawmakers repurpose active, generally agreeable legislation to force debates on completely unrelated controversies.
Senator Gallego's first proposal, Senate Amendment 4438, focuses strictly on transparency. It requires the Office of Management and Budget to quantify exactly how much money these waivers are generating for the Russian Federation.
The language mandates a recurring public disclosure. I have the exact phrasing from the congressional record here.
Go ahead.
It reads, "Not later than 7 days after the date of the enactment of this act, and every 7 days thereafter, the Director of the Office of Management and Budget shall post on a publicly accessible website of the federal government an estimate for the preceding 7 days of the dollar value of exports of crude oil and petroleum products from the Russian Federation enabled by each active waiver.
The goal is to put a precise dollar figure on the sanctions relief. Critics estimate that unlocking these shipments involves roughly 145 million barrels of oil, representing billions of dollars in potential revenue.
The second proposal escalates the response from reporting to direct cancellation. Senate Amendment 4433 seeks to nullify the Treasury's actions entirely.
The text of 4433 is unambiguous. It states, on and after the date of the enactment of this act, the following licenses issued the Office of Foreign Assets Control of the Department of the Treasury shall have no force or effect.
It specifically names General Licenses 133 and 134. If passed, it would instantly revoke the temporary authorizations and reinstate the strict enforcement of the energy sanctions against those shipments.
The third piece of this legislative package, Senate Amendment 4429, provides the underlying context for why lawmakers are challenging the executive branch so aggressively on this specific issue.
Amendment 4429 is a sense of Congress resolution. These do not carry the force of law, but they serve as formal declarations of the legislative branch's position. In this case, it outlines the intelligence reports surrounding the U.S. conflict with Iran.
The text cites the February 2026 strikes on Iran and the subsequent retaliatory attacks against American assets across 12 different countries. Crucially, it highlights reports that the Russian Federation is actively sharing intelligence and providing assistance to Iran during these hostilities.
By mid-March 2026, 13 members of the United States Armed Forces had been killed as a result of those attacks. That intelligence transforms a debate about global energy markets into a direct security concern.
The findings in the amendment synthesize those two tracks. I will read directly from the submission. It is the sense of Congress that Congress condemns easing sanctions on the Russian Federation, as it is continuing its brutal war against Ukraine and helping Iran target United States personnel and assets across the region.
This situation reveals a fundamental dispute over statutory authority and congressional oversight. In 2017, Congress passed the Countering America's Adversaries Through Sanctions Act, commonly referred to as CAATSA.
CAATSA includes a provision requiring the executive branch to notify Congress 30 days before making any major shifts in sanctions policy regarding Russia. The purpose of that window is to give lawmakers time to review and potentially block the relief.
Opponents of the administration's move argue that issuing a 30-day general license effectively bypasses the CAATSA notification requirement. Because the waiver itself expires in 30 days, the sanctions relief occurs entirely within the period Congress was supposed to have for review.
To address this perceived bypass, Senator Gallego partnered with Representative Sam Liccardo, a Democrat from California, to send a formal inquiry to Treasury Secretary Scott Bessent on March 9th. They demanded a detailed justification for the licenses, with a response deadline of March 14th.
At the same time, pressure is mounting on committee leadership to initiate formal hearings. Lawmakers have publicly urged Senator Tim Scott, the Republican from South Carolina who chairs the Senate Banking Committee, to compel Secretary Bessent to testify.
The Banking Committee holds jurisdiction over international sanctions and financial warfare, making it the primary venue for any structural overhaul of OFAC's licensing authority.
We are also seeing parallel legislative efforts from other members aiming to tighten the restrictions permanently. Senator Michael Bennet, a Democrat from Colorado, has co-sponsored the DROP Act, which would mandate secondary penalties on purchasers who buy Russian crude above the established price caps.
Senator Lindsey Graham, a Republican from South Carolina, has introduced the Sanctioning Russia Act. That proposal contemplates applying tariffs to nations that continue importing large volumes of Russian energy, directly targeting intermediaries.
All of these bills and amendments face procedural hurdles. Senator Gallego's proposals were ordered to lie on the table after receiving an objection from Senator John Barrasso, a Republican from Wyoming.
When an amendment is ordered to lie on the table, it is formally filed and printed in the congressional record, but it is not pending for an immediate floor vote. It remains available if the sponsor can secure unanimous consent or attach it to a moving piece of legislation later.
The administration maintains that executing foreign policy requires flexibility. When domestic consumers are facing a 20% increase at the gas pump, the executive branch often utilizes its administrative tools to alleviate that economic pressure.
From the perspective of the Treasury Department, managing the global oil supply requires pragmatic decisions about where energy originates and how it is refined, especially when major shipping lanes are compromised.
However, the legislative branch operates under a different set of priorities. For the lawmakers drafting these amendments, any policy that injects capital into a foreign government currently assisting in attacks against American service members is unacceptable, regardless of the corresponding benefits to the domestic energy market.
As the 30-day window on General Licenses 133 and 134 draws to a close, Congress will be watching to see if the Treasury Department attempts to renew the authorizations.
If a renewal is announced, we can expect the calls for committee hearings and binding floor votes to intensify significantly.
The debate over sanctions relief perfectly illustrates the difficulty of balancing international security objectives with domestic economic realities. That tension between geopolitical strategy and the everyday costs borne by consumers brings us to our next topic.
We are shifting our attention to domestic financial policy. We will examine the growing legislative movement surrounding economic populism, focusing on proposed changes to corporate taxes and the regulation of algorithmic pricing.
And that shift toward domestic financial policy is highly visible right now in a series of amendments proposed to Senate Bill 1383.
Right. S. 1383 is ostensibly a Veterans Affairs bill, but it is currently serving as the primary legislative vehicle for a comprehensive suite of economic proposals from the Democratic caucus. Lawmakers are responding directly to voter pressure regarding inflation and corporate pricing power.
We will start with the healthcare market. Senator Lisa Blunt Rochester, a Democrat from Delaware, submitted Senate Amendment 4447. This is a major legislative push to stabilize the Affordable Care Act marketplaces, primarily by addressing the recent lapse in enhanced premium tax credits.
Those subsidies originally passed under the American Rescue Plan and the Inflation Reduction Act. They expired on December 31, 2025. Because Congress did not extend them before the 2026 open enrollment period began, consumers are currently seeing significant premium increases on healthcare.gov.
Exactly. The Blunt-Rochester Amendment seeks to extend those temporary enhanced premium tax credits through January 1, 2029. To handle the immediate fallout of the lapsed subsidies, it mandates an additional open enrollment period for the 2026 plan year, running from the date of enactment through the end of the year.
The mechanics of this extension rely heavily on insurer compliance and consumer outreach. The amendment includes a $1,000 per day penalty for each affected individual if an insurance issuer fails to provide timely notification regarding changes in premium assistance eligibility.
To fund that consumer outreach, the legislation revitalizes the Navigator program. The text reads, "The Secretary shall obligate $100 million out of amounts collected through the user fees on participating health insurance issuers. For fiscal year 2026. It also explicitly prohibits those navigators from charging fees or requesting remuneration from applicants."
There is a particularly interesting administrative streamlining provision in here as well. The amendment permits automatic enrollment from bronze to silver level plans. For consumers who are eligible for cost-sharing reductions, those benefits are only available if they enroll in a silver plan. Allowing exchanges to automatically bump eligible enrollees from bronze to silver maximizes their federal subsidies without requiring them to navigate the website again.
The proposal also places hard caps on the repayment limits for premium tax credit overpayments. If a household earning below 400% of the federal poverty line underestimates their annual income, this provision caps how much of that advanced tax credit they have to pay back to the IRS at tax time,
which provides a degree of predictability for enrollees who have fluctuating incomes, like independent contractors or seasonal workers. Moving from the complexities of health insurance to the energy sector, we have another major proposal attached to this same underlying bill.
Yes, Senator Sheldon Whitehouse, a Democrat from Rhode Island, submitted Senate Amendment 4410, known as the Big Oil Windfall Profits Tax Act. This targets major crude oil producers and importers.
The phrase windfall profits tax has a long history in congressional energy debates, usually surfacing when retail gas prices spike. In this iteration, the legislation specifically defines the target as covered taxpayers, meaning those extracting or importing an average of more than 300,000 barrels of crude oil per day.
For those entities, the amendment imposes a 50% excise tax on excess profit per barrel. Here is how the text establishes the levy. In addition to any other tax imposed under this title, in each calendar quarter, there is hereby imposed on any covered taxpayer an excise tax at the rate determined under subsection B on 1. Each barrel of taxable crude oil extracted by the taxpayer within the United States.
The formula for determining that excess profit is based on the difference between the average Brent crude price during a given calendar quarter and the average price recorded throughout 2025. For years after 2026, the baseline is adjusted for inflation.
And the revenue from this excise tax does not go into the general fund. The amendment establishes the Protect Consumers from Gas Hikes Fund. All generated revenues are deposited there to finance a rebate program for individual taxpayers.
Eligible individuals would receive a quarterly refundable tax credit based on the amount in the fund. The credit phases out based on adjusted gross income. It reduces by 5% for income exceeding $75,000 for single filers, $112,500 for heads of household, and $150,000 for joint returns.
Supporters of the measure, including environmental groups like the League of Conservation Voters, argue this is necessary to curb industry profitability during supply shocks and redirect those funds to consumers. They point out that exempting companies producing less than 300,000 barrels per day protects about 70% of domestic producers, maintaining market competition.
Opponents, represented by coalitions including the National Taxpayers Union, approach this from a supply-side perspective. They caution that imposing a 50% excise tax on the largest producers will inevitably reduce domestic extraction. Their position is that shrinking the domestic supply will increase reliance on imports and ultimately drive the baseline price of fuel even higher.
Senator Whitehouse is addressing more than just energy revenues in this session. He also submitted Senate Amendment 4411.
As the congressional record clearly states, this act may be cited as the Medicare and Social Security Fair Share Act.
This proposal enters the ongoing debate over entitlement solvency. Recent projections show the Medicare Hospital Insurance Trust Fund facing depletion by 2040, and the Social Security Old Age and Survivors Insurance Trust Fund exhausting its reserves by 2032. The Fair Share Act attempts to close that funding gap entirely through taxation on high-income earners.
The most prominent mechanism here is the modification of the payroll tax cap. Under current law, earnings above a certain threshold are exempt from Social Security payroll taxes. This amendment subjects earnings above $400,000 to those taxes.
It goes further by establishing a new 1.2% tax on hospital insurance for wages exceeding $400,000 for individuals and $500,000 for joint filers. It also increases the net investment income tax to 17.4% for certain high-income individuals, trusts, and estates.
Which represents a fundamental policy choice. When addressing the projected shortfalls in these trust funds, Congress basically has three levers to pull: increase revenue, reduce benefits, or raise the retirement age. This amendment relies entirely on the revenue lever, specifically targeting unearned income and high-wage earners.
The text directs that 71.3% of the new investment taxes go to the Old Age and Survivors Trust Fund, 10.3% to the Disability Insurance Fund, and 28.7% to the Hospital Insurance Fund. This would apply to taxable years beginning after December 31st, 2025.
Critics of the measure, including the Tax Foundation, argue that pushing combined marginal tax rates near 60% for top earners would negatively impact economic growth, capital investment, and U.S. competitiveness.
While White House focuses on macro-level taxation and commodity markets, another piece of this populist puzzle targets the digital retail economy directly. Senator Ruben Gallego, a Democrat from Arizona, introduced Senate Amendment 4437, titled the One Fair Price Act of 2026.
This addresses the practice of dynamic pricing, specifically algorithmic models that use personal data to charge different consumers different prices for identical items.
The legislation defines this as surveillance-based price setting. Let me read the central prohibition. It shall be unlawful for a person to offer or charge different prices to different consumers for the same or a substantially similar product or service, using, informed by, or based on, in whole or in part, surveillance data.
The definition of surveillance data here is extremely broad. It encompasses personal information, behavioral patterns, and biometrics, whether a company gathers that data directly or purchases it from a third-party broker.
To prevent the law from outlawing standard retail practices, the amendment outlines specific safe harbors. Price differentiation is permitted if it is based solely on reasonable costs associated with providing the service.
You know, I love reading the mechanics of a statutory safe harbor.
I do know that about you. The bill also protects bona fide discounts for specific groups, like veterans, students, or senior citizens, as well as transparent loyalty programs.
However, to qualify for those exceptions, a business must clearly disclose its eligibility criteria and is strictly prohibited from using the collected data for any other purpose, such as targeted advertising.
The enforcement section is where this bill gets real teeth. It grants the Federal Trade Commission authority to regulate violators as if they committed unfair or deceptive acts under the FTC Act. It authorizes state attorneys general to bring civil actions on behalf of their residents.
And it creates a private right of action for individual consumers. That is a significant detail. A plaintiff can establish a presumptive violation simply by demonstrating that two individuals were offered different prices for a substantially similar product at the same time.
Perhaps the most impactful provision for corporate liability is the section regarding arbitration. The amendment renders pre-dispute arbitration agreements and joint action waivers invalid and unenforceable for claims brought under this act.
Invalidating mandatory arbitration clauses opens the door to class action lawsuits. For companies relying on dynamic pricing models, the threat of class action litigation represents a massive shift in their legal risk profile. The legislation does mandate a joint study by the FTC and the Small Business Administration's Office of Advocacy to evaluate the economic impact on small businesses.
The text explicitly excludes the insurance and credit industries from these requirements, acknowledging the distinct regulatory frameworks that already govern those sectors. Conversely, it specifically extends these prohibitions to air carriers and ticket agents, ensuring that federal law does not preempt state-level consumer protection claims against airlines.
Taken together, these amendments illustrate a cohesive legislative strategy. Whether it is healthcare subsidies, energy excise taxes, entitlement funding, or regulating retail algorithms, the focus is squarely on redistributing corporate revenues and restricting corporate pricing power in favor of the consumer.
It is an expansive view of congressional authority over the marketplace. We will continue monitoring S. 1383 to see which, if any, of these amendments secure the votes for inclusion in the final package. Moving away from economic policy, we need to examine an emerging constitutional and demographic dispute. Up next, we look at the growing debate over apportionment and the 2030 census battle.
The underlying bill here is the Veterans Advisory Committee on Equal Access. However, as we often see in the Senate, legislation moving toward a floor vote becomes a vehicle for members to attach amendments addressing entirely unrelated national priorities. In this instance, we are looking at a fundamental question about how political power is distributed in the United States.
The amendment in question is Senate Amendment 4452, introduced by Senator John Kennedy, a Republican from Louisiana. The official title printed in the congressional record states exactly what the legislation aims to do: exclusion of individuals not lawfully present in the United States from number of persons used to determine apportionment of representatives and number of electoral votes.
That is a highly descriptive title. To understand the mechanics of what Senator Kennedy is proposing, we have to look at the intersection of constitutional text and federal statute. The 14th Amendment dictates that representation in the House is apportioned among the several states according to their respective numbers, counting the whole number of persons in each state. Kennedy's amendment seeks to redefine how the federal government applies that specific clause during the decennial census.
Legally, the amendment achieves this by modifying Section 22A of the 1929 Census Act. The drafted text inserts the phrase, "and individuals who are not lawfully present in the United States," immediately following the existing statutory phrase.
We should explore the historical origin of that not taxed language because it provides crucial context for this maneuver. Both Article 1 of the original Constitution and the 14th Amendment included the phrase, "excluding Indians not taxed." This was a foundational mechanism for determining the apportionment base.
Historically, Native Americans living on reservations who did not pay federal taxes were excluded from the official count used for congressional representation. That specific constitutional exclusion essentially became obsolete following the passage of the Indian Citizenship Act of 1924, which granted full U.S. citizenship to indigenous peoples. Nevertheless, the original phrasing remains embedded in the foundational statutes governing the Census Bureau.
Senator Kennedy is using that historical artifact as an insertion point for a completely contemporary issue. By placing undocumented immigrants directly adjacent to the historical not taxed category within the U.S. Code, the amendment attempts to establish a statutory carve-out for apportionment without having to amend the Constitution itself.
The stakes attached to this maneuver are immense. Apportionment dictates exactly how the 435 seats in the House of Representatives are divided among the 50 states. Because each state's electoral college allocation is equal to its total number of House and Senate seats, altering the census count fundamentally rewrites the map for presidential elections as well.
Let us look at the underlying mathematics. Demographers at Pew Research estimate there are approximately 11 to 12 million undocumented residents currently living in the United States. This population is not distributed evenly across the map. These residents are heavily concentrated in specific states, primarily California, Texas, New York, and Florida.
If you remove those individuals from the mathematical base, the balance of power shifts. Pew calculates that excluding undocumented residents from the final tally could redistribute 3 to 4 House seats. Those seats would generally migrate away from blue-leaning urban centers and toward red states.
3 or 4 seats might sound like a minor adjustment within a 435-member chamber, but recent history demonstrates how narrow congressional majorities can be. A swing of 4 seats alters the entire legislative calculus for whichever party holds the gavel. Furthermore, it moves those exact same votes in the Electoral College, potentially deciding a close presidential race.
This legislative push does not exist in isolation. It aligns seamlessly with the administration's stated objectives for the Commerce Department, the cabinet agency that oversees the Census Bureau. In August 2025, President Trump announced plans for a new and highly accurate census that explicitly excludes undocumented immigrants.
That announcement mirrors identical efforts from his first term in 2020. Those previous attempts faced intense pushback and were ultimately blocked by the federal courts. However, the administration is laying the groundwork early this time around. The logistical preparations for a decennial census take years. Formulating the master address file, testing data collection methods, and finalizing the operational plan requires an extensive lead time.
Which explains why we are seeing legislative action in early 2026. Last September, the House passed a 2026 census funding bill featuring a specific rider known as Section 556. That provision strictly prohibits any federal funds from being used to include unlawful aliens in the official apportionment count.
That House vote triggered immediate responses from Democratic lawmakers. Representative Robert Garcia, a Democrat from California, sent a formal letter to Commerce Secretary Howard Lutnick late last August. Garcia demanded detailed explanations regarding how the department actually plans to implement this exclusionary directive, citing severe concerns over data accuracy.
Implementation presents a fascinating technical challenge for the Census Bureau. The standard decennial census form does not currently ask respondents to identify their citizenship or immigration status.
Exactly. During the 2020 cycle, the administration attempted to add a citizenship question directly to the printed questionnaire. That effort was struck down by the Supreme Court based on violations of the Administrative Procedure Act. If the government cannot directly ask the question on the form, the Commerce Department will likely have to rely heavily on administrative records.
That process involves cross-referencing census responses with existing federal databases maintained by the Department of Homeland Security or the Social Security Administration. Demographers refer to this technique as statistical modeling, estimating the undocumented population tract by tract.
Critics point out that statistical modeling introduces a significant margin of error into a process that the Constitution mandates must be an actual enumeration. Every single person counted affects the final formula. Congress uses a mathematical algorithm called the method of equal proportions, adopted in 1941. It calculates priority values to assign seats number 51 through 435, aiming to keep the ratio of people to representatives as balanced as mathematically possible.
Because every state automatically receives one seat, regardless of population size. When research organizations project a shift of several seats, they are running state population estimates through that exact Huntington Hill formula, minus the estimated millions of undocumented individuals.
The constitutional requirement remains the ultimate hurdle for this entire endeavor. The Supreme Court has repeatedly affirmed over the decades that the 14th Amendment requires a total person count. Whether the change comes through Senator Kennedy's statutory amendment or via executive action at the Commerce Department, it guarantees a high-profile showdown at the Supreme Court.
The judicial question will center on whether lawmakers or executive agencies possess the authority to redefine the word persons differently from how it was understood when the 14th Amendment was ratified in 1868.
Proponents argue strongly that allocating political representation based on non-citizens fundamentally dilutes the voting power of actual American citizens. Senator Kennedy has made immigration enforcement a central pillar of his legislative agenda, evident in his recent co-sponsorship of the Stop Illegal Aliens Drunk Driving Act. For lawmakers taking this stance, redefining apportionment serves as the logical culmination of their border security platform.
Opponents counter that the framers of the Constitution intentionally selected the word persons instead of citizens for the apportionment clause. They argue the historical record shows representation was designed to encompass everyone physically living within a district, utilizing local infrastructure and participating in the regional economy.
Currently, Senate Amendment 4452 has been ordered to lie on the table. In procedural terms, it is holding in a parliamentary waiting room. Yet it functions perfectly as a definitive statement of legislative intent for the Republican conference as 2030 approaches.
As this constitutional debate continues gathering momentum in the halls of Congress and the federal courts, another major structural shift is taking shape regarding government data collection. Up next, we will shift our focus to how lawmakers are modernizing privacy in the era of DOGE.
When examining federal data collection today, the primary friction point occurs between aggressive administrative modernization and traditional civil liberties. The current administration has made it a central priority to break down the traditional information silos that separate different federal agencies.
The operational theory behind that initiative is that a more integrated federal data system allows the government to root out waste, streamline services, and track expenditures with unprecedented precision. It is the driving philosophy behind the new Department of Government Efficiency.
Exactly. If the Internal Revenue Service, the Department of Veterans Affairs, and the Department of Health and Human Services can seamlessly cross-reference their databases, the government operates much more like a modern technology company. However, that exact capability is precisely what raises red flags for lawmakers focused on the Fourth Amendment.
Enter Senator Ron Wyden, a Democrat from Oregon. He has introduced two substantial amendments to Senate Bill 1383, designed to erect immediate statutory boundaries around how the federal government handles and collects digital information. Let us look first at Senate Amendment 4415, titled the Privacy Act Modernization Act of 2026.
We need to look at the historical baseline here. The original Privacy Act was passed in 1974. At that time, federal records were predominantly physical documents stored in manila folders inside metal filing cabinets. The statute was written to regulate a system of records where information was retrieved by an individual's name or a specific identifying number.
That framework has struggled to keep pace with modern data architecture. In a cloud-based environment where algorithms can match fragmented metadata across dozens of platforms in milliseconds, the 1974 definition of a record is increasingly obsolete. Senator Wyden's amendment completely rewrites those definitions.
Under this proposal, the definition of a record expands to include any personally identifiable information, commonly referred to as PII, processed by an agency. Furthermore, the amendment defines process as any operation performed on that data, whether manual or automated. Storing, analyzing, organizing, or modifying the data all fall under this new umbrella.
The amendment also imposes strict limitations on how agencies can share this information. It explicitly requires that agencies take reasonable efforts to ensure any disclosed record contains the absolute minimum amount of information necessary to accomplish the purpose of the disclosure.
That data minimization requirement strikes directly at the concept of bulk information sharing. If an efficiency audit requires checking a specific metric, the agency cannot simply hand over the entire server contents. They must filter the data first, and the penalties for violating these new standards are severe.
The civil remedies alone represent a significant escalation. Individuals would be allowed to sue for non-pecuniary damages with a guaranteed minimum recovery of $1,000 for successful suits involving intentional or willful agency misconduct. But the criminal penalties are where this legislation truly shows its teeth. Reading directly from the congressional record, a person who commits an offense described in the previous sentence with the intent to sell, transfer, use, or disclose a record described in that sentence for commercial advantage, personal gain, or malicious harm shall be guilty of a felony.
And the punishment attached to that felony classification is up to 10 years in federal prison and a fine of up to $250,000. Lawmakers are sending a clear signal that treating citizen data as a tradable commodity or using it for unauthorized purposes will carry career-ending, life-altering consequences.
There is a fascinating mechanical detail regarding how this law would be implemented. The text establishes a tiered effective date structure. For the vast majority of the federal government, the amendments would take effect 2 years after the date of enactment. That provides a standard transition period for agencies to update their compliance protocols and retrain personnel.
But there is a very specific carve-out, a fast-track implementation schedule that takes effect on day one.
Correct. Section 4, subsection C of the amendment dictates that the 2-year grace period does not apply to the United States DOGE service, the U.S. DOGE Service Temporary Organization, or any associated DOGE teams, as described in the President's Executive Order 14158.
It applies instantly to any special government employee, temporary expert, or consultant working within those parameters. This is a surgical legislative strike. By naming these entities specifically, Senator Wyden is attempting to ensure that the administration's highest-profile government reorganization project operates entirely within these tightened privacy constraints from the moment it begins accessing federal databases.
While that amendment addresses the handling of data the government already possesses, Wyden's second proposal tackles how the government collects new data in the physical world. Senate Amendment 4414 introduces the Cell Site Simulator Warrant Act of 2026.
Cell site simulators are more commonly known by the colloquial term stingrays. They are surveillance devices utilized by law enforcement and intelligence agencies to track mobile phones. To understand why they attract so much legislative scrutiny, it helps to know how they function on a technical level.
A standard mobile phone is constantly pinging the nearest legitimate cellular tower to maintain a connection. A stingray operates by spoofing that signal. It essentially tricks every device within a certain radius into connecting to the surveillance equipment instead of the commercial network.
Exactly. The simulator essentially broadcasts a signal that says, "I am the strongest tower in the area. Connect to me." When the target's phone connects, the device captures its location, its unique identifying numbers, and in some configurations, the content of unencrypted communications. The fundamental issue is that the device does not single out the target.
It captures the data of every innocent bystander in the vicinity. People walking their dogs, sitting in coffee shops, or driving down the street. Under current regulations, the deployment of this technology occupies a gray area, often utilized without traditional oversight.
This legislation proposes a general prohibition on using these devices anywhere within the United States, followed by narrow, strictly regulated exceptions. If a law enforcement agency wants to use a stingray, they must obtain a specialized judicial warrant.
The standard for obtaining that warrant is exceptionally high. According to the text, a court may issue authorization, quote, only if the law enforcement agency demonstrates that other investigative procedures have been tried and have failed.
That is known as an exhaustion requirement. Investigators cannot use a cell site simulator as a convenient first step. They have to prove to a judge that less intrusive methods, such as requesting standard location records from the telecom provider, were insufficient or too dangerous to attempt.
The amendment also mandates strict limitations on the duration of the surveillance. Warrants would be capped at 30 days, preventing open-ended tracking operations. Furthermore, the agency must specify the likely area of effect and certify that it is the narrowest reasonably possible footprint to obtain the necessary information.
There are also rigorous rules regarding the bystander data we mentioned earlier. The Attorney General would be required to adopt specific minimization procedures. Any data collected from devices belonging to non-targets must be destroyed at the earliest possible opportunity.
The proposal does include an emergency use provision for scenarios involving immediate danger of death, organized crime activities, or threats to national security. However, if an agency deploys a simulator under those emergency parameters, they must apply for a retrospective warrant within 48 hours.
If the judge subsequently denies that application, the agency must promptly destroy all evidence derived from the device, and the government is required to serve notice to the individuals whose data was swept up in the operation.
To enforce compliance, the amendment creates a private right of action, allowing individuals subjected to unlawful operation to bring civil suits for statutory damages. It also mandates an annual joint report from the Inspectors General of the Justice Department, Homeland Security, Defense, and the intelligence community, detailing exactly how often these devices are requested and deployed.
This connects directly to broader bipartisan momentum on Capitol Hill regarding electronic privacy. Just last week, on March 12, 2026, we saw the introduction of the Government Surveillance Reform Act.
That package was co-sponsored by Representative Warren Davidson, a Republican from Ohio, Representative Zoe Lofgren, a Democrat from California, and Senator Mike Lee, a Republican from Utah, alongside Senator Wyden.
That broader coalition is pushing to require warrants for searches of Americans' data under Section 702 of the Foreign Intelligence Surveillance Act, and attempting to close loopholes that allow federal agencies to purchase sensitive location data from commercial data brokers. The Cell Site Simulator Bill operates as a specialized companion to those broader efforts.
Taken together, these amendments illustrate a comprehensive push to codify digital privacy rights into federal statute. On one side, lawmakers are attempting to build walls around the massive troves of personal information already residing on government servers, specifically targeting the speed and scope of new efficiency initiatives.
On the other side, they are trying to restrict the actual technological tools used to pull new data out of the physical environment. As digital architecture outpaces the frameworks designed in the 1970s, Congress is being forced to articulate exactly where the boundaries of the Fourth Amendment lie in an era of artificial intelligence and mass data aggregation.
This ongoing calibration between civil liberties and executive authority is playing out across multiple branches of government simultaneously. While the Senate debates these surveillance guardrails, another fundamental institutional battle is brewing over the structure of the judiciary itself. Moving forward, we will examine the escalating legislative maneuvers surrounding the Supreme Court legitimacy push.
You mentioned the Senate debating surveillance guardrails. And what is fascinating about this transition is how lawmakers are using the exact same legislative vehicle to fundamentally rethink the judicial branch. We are looking at Senate Bill 1383, which on its face is a bill to establish the Veterans Advisory Committee on Equal Access.
Right. In this chamber, a bill about veterans' access frequently becomes the host organism for sweeping constitutional debates. Senator Sheldon Whitehouse, a Democrat from Rhode Island, has attached a triad of amendments to S. 1383. Taken together, they represent a coordinated institutional attempt by Senate Democrats to apply strict, binding oversight to the Supreme Court.
Let us start with the first piece of that triad, Senate Amendment 4408, the Supreme Court Ethics, Recusal, and Transparency Act of 2026, or the SCIRT Act.
The core mechanism here is an absolute mandate. The text reads, "The Supreme Court of the United States shall, after appropriate public notice and opportunity for comment, issue a code of conduct for the justices of the Supreme Court."
The key word there is shall. The court currently operates under an ethics code it adopted internally in 2023, but critics have consistently pointed out that the internal code lacks an enforcement mechanism. The SCERT Act creates one by establishing a judicial investigation panel.
And the composition of that panel is particularly interesting. The amendment requires the panel to be made up of 5 circuit court judges selected randomly from among the chief judges of the United States circuits.
So you have lower court judges reviewing complaints against Supreme Court justices. The panel is empowered to hold hearings, take sworn testimony, and issue subpoenas. If they find an ethics violation, they present their findings to the Supreme Court for disciplinary action.
The recusal requirements in this amendment are heavily detailed. It targets the financial and personal relationships of the justices. If a justice, or their spouse or minor child, received income, a gift, or reimbursement from a party involved in a proceeding within the preceding 6 years, that justice must disqualify themselves.
The 6-year look-back period is a direct response to recent reporting regarding undisclosed gifts and travel funded by private citizens who occasionally have interests before the court. The proposal codifies judicial ethics into federal statute, actively moving the court away from a model of voluntary, self-policing compliance.
The SCERT Act also tackles the influence of third-party litigation. It introduces stricter disclosure rules for amicus curiae briefs, commonly known as friend of the court briefs.
These are the briefs filed by outside organizations trying to persuade the justices how to rule. The amendment requires anyone filing an amicus brief to list the name of any person who contributed to its preparation, or who contributed more than $100,000 to the organization in the previous year.
It is an attempt to map out the financial networks behind these legal arguments, bringing transparency to the entities quietly shaping Supreme Court precedents. For context on the timing here, in mid-February of 2026, the Supreme Court actually adopted automated recusal software.
That is an internal tool designed to cross-check case parties and attorneys against the justice's financial data. They also implemented new filing rules for stock tickers and litigant lists that went into effect on March 16th.
Proponents of the court's internal efforts point to that software as proof that the judiciary is actively modernizing its conflict of interest protocols. Supporters of the CDRT Act argue that internal software is meaningless without an external body verifying the inputs and enforcing the outcomes.
That tension between internal administration and external oversight flows directly into the Second Amendment in this package, the Disclose Act of 2026. This is Senate Amendment 4409.
We usually talk about the Disclose Act in the context of federal elections, closing loopholes for foreign nationals, mandating that organizations spending more than $10,000 reveal their beneficial owners, and requiring top 5 funder lists in political advertisements.
This version explicitly extends those campaign finance regulations to the judicial confirmation process. The amendment contains a specific section titled Reporting of Federal Judicial Nomination Disbursements.
And the findings section of the amendment does not mince words regarding the motivation. Quote, "The prevalence and pervasiveness of dark money drives public concern about corruption in politics and the courts."
It fundamentally reclassifies advocacy around judicial nominations. If an organization buys television ads or digital promotions to support or oppose a Supreme Court nominee, the Disclose Act treats those expenditures exactly like campaign-related disbursements for a Senate or presidential candidate.
We have seen tens of millions of dollars spent on advertisements during recent Supreme Court confirmation battles. Because the law currently treats judicial nominations differently than political elections, the groups funding those ads are largely exempt from traditional campaign finance disclosure requirements.
Senator Whitehouse is arguing that the public has a right to know if the individuals funding campaigns to confirm a judge have active business before that very same judge. The amendment essentially collapses the distinction between a political campaign and a judicial confirmation campaign for the purposes of financial transparency.
While the ethics code and the dark money regulations both focus on the behavior surrounding the court, the third proposal in this triad targets the actual structural architecture of the bench itself. This is Senate Amendment 4407, the Supreme Court Biennial Appointments and Term Limits Act of 2026.
This is where we get into some truly creative constitutional drafting. Article 3 of the Constitution grants federal judges lifetime tenure. They hold their offices during good behavior. Therefore, you cannot simply pass a law firing a Supreme Court justice after 18 years.
A traditional term limits proposal would require a constitutional amendment, which requires a 2/3 vote in both the House and Senate, plus ratification by 3/4 of the states. That is an incredibly steep hill to climb.
To bypass that requirement, this legislation attempts to redefine the job description rather than the length of employment. It creates a rotational bench by dividing the court's workload into appellate jurisdiction cases and original jurisdiction cases.
Let us break that down, because it is the linchpin of the whole operation. Original jurisdiction cases are those where the Supreme Court is the first and only court to hear the dispute, like a boundary disagreement between two states. Those make up a tiny fraction of the court's docket.
Appellate jurisdiction cases are the ones we all read about. Cases appealed up from the lower circuit courts or state Supreme Courts. This amendment explicitly states, quote, "Only the 9 most recently appointed justices of the Supreme Court of the United States, who are not unavailable due to a temporary absence, shall preside over appellate jurisdiction cases.
Under this system, every justice technically keeps their lifetime appointment. They never lose their title, their salary, or their office. However, once a justice becomes the 10th most senior member of the court, they are rotated off the active appellate bench. They are restricted to hearing those rare original jurisdiction cases, or stepping in if one of the active 9 is recused.
To ensure this rotation happens smoothly, the bill mandates a strict appointment schedule. The president is required to appoint one justice during the first year of their term, and a second justice during the third year of their term.
2 appointments per 4-year presidential term. Over an 18-year period, you get exactly 9 justices. It standardizes the nomination process, completely detaching it from the unpredictable timing of retirements or deaths.
Advocates argue this would significantly lower the temperature of confirmation hearings. Right now, a sudden vacancy can completely alter the ideological balance of the court for decades, turning the confirmation process into an existential political battle. If everyone knows a new seat opens up precisely every 2 years, the stakes of any individual confirmation are inherently reduced.
It is a profound rethinking of how the third branch of government operates. It attempts to align the judiciary with the biennial election cycle, tethering the makeup of the court much more closely to the results of recent presidential elections.
As fascinating as the mechanics are, we need to look at the legislative reality. These proposals face insurmountable opposition from Senate Republicans.
The Republican conference views these measures as a direct partisan attack on the current conservative majority. They argue that implementing a rotational bench by statute rather than constitutional amendment is blatantly unconstitutional, and that subjecting the justices to lower court ethics reviews violates the separation of powers.
Because S. 1383 is currently subject to the legislative filibuster, these amendments would require 60 votes to advance. With a divided chamber, there is no viable path forward for the SCERT Act, the Disclose Act, or the Biennial Appointments Act in this Congress.
The introduction of these amendments is a coordinated messaging effort. Senate Democrats are using the floor to formally articulate their preferred structural remedies, testing the legal arguments, and getting members on the record regarding judicial reform.
They are building out the legislative architecture now, preparing for a future scenario where they might possess both the majorities and the procedural leverage necessary to enact them.
The debate over the boundaries of executive and judicial power is clearly intensifying. Moving forward, we will see that tension applied to another constitutional authority, as we turn our attention to the growing outrage over presidential pardons and prison perks.
Executive authority always provides a fascinating friction point between the branches of government. The pardon power, specifically, is one of the most absolute tools granted to the presidency under Article 2 of the Constitution. Congress cannot veto a pardon. They cannot override it. So when lawmakers want to exert influence over clemency decisions or the administration of the federal prison system, they have to use secondary levers. We are seeing exactly how they engineer those levers in the congressional record this week.
We have 2 distinct situations unfolding that illustrate this dynamic perfectly. The first involves the incarceration and potential clemency of Ghislaine Maxwell. The second involves a pardon that has already been executed for the former president of Honduras, Juan Orlando Hernandez. Let us begin with the prison administration aspect. We are looking at Senate Amendment 4399, introduced by Senator Chuck Schumer, Democrat of New York. He is attempting to attach this to S. 1383, which is fundamentally a Veterans Advisory Committee bill.
The amendment is titled the Sex Offender Security Classification Integrity Act of 2026. It is a direct legislative response to a highly publicized Bureau of Prisons decision from July 2025. Maxwell, who is serving a 20-year sentence following her December 2021 conviction for sex trafficking minors, was transferred from a low-security facility in Tallahassee, Florida, to a minimum security camp in Bryan, Texas.
To understand the legislative reaction, we need to understand the structural difference between those 2 designations. The Bureau of Prisons has very specific definitions. A low-security facility has a double-fenced perimeter and a higher staff-to-inmate ratio. A minimum security facility, often referred to as a prison camp, permits relatively free inmate movement and can include access to the surrounding community or off-site work programs. Senator Schumer's amendment argues that placing an individual with a sex offender public safety factor in a minimum security environment constitutes a departure from established protocol.
That departure is the crux of the legislative text. The amendment notes that public reporting indicated the transfer followed 2 days of meetings between Maxwell and Deputy Attorney General Todd Blanche. Consequently, Congress is stepping in to codify the baseline housing requirements. If passed, this bill would mandate that any inmate classified as a sex offender must be housed, at a minimum, in a low-security facility.
I want to read directly from the findings section of Senator Schumer's amendment, because the language is highly specific regarding the administration's handling of the case. It reads, "The apparent deviation from ordinary bureau policy in Maxwell's case, and the subsequent public defense of that deviation by a senior Department of Justice official, raises serious concerns about whether the security classification system is being applied consistently, transparently, and without favoritism."
That is the core argument being entered into the official record. The amendment also features a fascinating enforcement mechanism. It includes a retroactive clause requiring the Director of the Bureau of Prisons to reverse any housing changes for sex offenders made on or after January 20th, 2025, that conflict with these new statutory standards. It removes the discretionary power from the Bureau for these specific classifications, aside from very narrow medical or geriatric exceptions that would require written notification to the House and Senate Judiciary Committees.
While Senator Schumer is addressing the conditions of her confinement, another amendment focuses on the possibility that her sentence could be commuted entirely. Senator Jackie Rosen, Democrat of Nevada, introduced Senate Amendment 4455, also aimed at the Veterans Bill. It is titled, "No Pardon for Ghislaine Maxwell." This is a sense of the Congress resolution.
Sense of the Congress resolutions are essentially formal declarations of the legislative branch's posture. They do not have the force of law, but they carry significant political weight by forcing members to go on the record regarding a specific issue. Senator Rosen introduced this following public comments from the president, indicating he possesses the authority to grant clemency in this case and declining to rule it out.
The text of Senator Rosen's amendment lays out the timeline of the June 2022 judgment of conviction in the Southern District of New York. Then it delivers the primary declarative statement, granting a pardon, commutation, or any other form of executive clemency to Ghislaine Maxwell would be inconsistent with the interests of justice and accountability for crimes involving the sexual exploitation of children. By introducing this, lawmakers are attempting to proactively establish a unified boundary before any executive action is taken.
Which brings us to the second half of this discussion, dealing with executive action that has already materialized. You cannot unring the bell of a presidential pardon. Once signed, the legal consequences of the conviction are erased. However, Congress retains its investigative and oversight capabilities, and they are deploying those tools aggressively regarding the clemency granted to Juan Orlando Hernandez.
For background, Juan Orlando Hernandez served as the president of Honduras from 2014 to 2022. He was convicted in a United States federal court of drug trafficking conspiracies, specifically involving the facilitation of tons of cocaine into the U.S. in partnership with organizations like the Sinaloa cartel. He received a sentence of 45 years. On December 1st, 2025, he was formally pardoned.
The executive branch argued the original prosecution was politically motivated. In response, Senator Catherine Cortez Masto, Democrat of Nevada, drafted Senate Amendment 4458. She proposed attaching it to S3183, which is a wildland firefighter safety bill. It is a striking example of using unrelated, must-pass, or broadly supported legislation as a vehicle for stringent executive oversight.
This amendment requires the Department of Justice to submit a comprehensive report to the Judiciary, Appropriations, and Foreign Relations Committees within 30 days of enactment. It demands all communications between the Office of the Pardon Attorney, the Attorney General, the Deputy Attorney General, and the White House regarding the December 1st pardon. But the most compelling part of this text is how it forces the department to interact with the trial evidence.
It is highly unusual to see specific exhibits from a federal trial immortalized in a Senate amendment. Usually, oversight requests ask for broad summaries. This document zeroes in on the exact pieces of evidence presented to the jury.
I will read from Section 4 of the amendment. It requires the DOJ to provide a narrative description of how any evidence exonerating Mr. Hernandez overcomes the weight of the evidence introduced at trial, such as pictures of Mr. Hernandez with drug traffickers at the 2010 World Cup, despite his claims he did not know them, the audio recordings of members of the MS-13 gang discussing their payments to Mr. Hernandez, the ledgers of the trafficker witness who was murdered in prison, and phone data showing co-conspirators physically visited the presidential palace of Mr. Hernandez at least twice.
By listing those specific evidentiary items, the Senate is preempting any vague explanations. If the administration maintains the stance that the prosecution was legally flawed or lacked sufficient evidence, this legislation requires them to publish a detailed narrative explaining exactly how they reached that conclusion, while looking at the cell phone tower data and the audio recordings. Furthermore, the amendment mandates that this entire report be made available on the department's public website.
The amendment also asks for a summary of the investigation timeline and explicitly requests a detailed description of the role played by prosecutor Emil Bove in the conviction. Lawmakers are mapping out the entire anatomy of the case, from the initial federal law enforcement investigation all the way to the president's desk.
It demonstrates the creative ways Congress pursues accountability when dealing with absolute executive powers. The Constitution does not require the president to explain a pardon to anyone. The power is plenary. Therefore, the legislative branch shifts its focus to the bureaucracy that supports the president. They use their authority over the Department of Justice, which they fund and oversee, to extract the paper trail. They cannot reverse the clemency granted to the former Honduran president, but they can ensure the rationale behind it is subjected to a rigorous public accounting.
These three amendments reveal a profound tension regarding the justice system. Whether it is dictating the security perimeter required for specific federal inmates, drawing a hard line against hypothetical future pardons, or demanding an exhaustive justification for past clemency decisions, lawmakers are utilizing the amendment process to insert themselves into decisions typically reserved for the executive branch and prison administrators.
It highlights why reading the full text of these proposals is so valuable. A summary might simply say Congress is looking into prison transfers or executive actions. The actual legislative text shows us the exact mechanisms they are designing to exert that pressure. Retroactive classification reversals, mandatory congressional notifications, and itemized demands for trial evidence narratives.
That wraps up our detailed review for this session. We have covered the complex maneuvering around judicial reform, the specific mechanics of prison classifications, and the oversight battles surrounding the pardon power. Thank you for joining us as we navigate the dense, essential realities of the congressional record. We will be back next week to break down the latest additions to the floor. And finally, I'd be remiss if I didn't mention this. While the Senate floor is currently paralyzed by a 32-day Homeland Security shutdown, tense debates over a multi-billion-dollar war, and the very real threat of a constitutional crisis over the census.
Just the light, breezy stuff.
The chamber did manage to find time for one piece of official business, a bipartisan resolution officially designating March 21st as National Osceola Turkey Day.
Ah, yes. Ensuring that the elusive, swamp-dwelling bird receives its proper federal recognition. I was just saying to myself, if we can't fund the Department of Homeland Security, at least we can stand up for America's most evasive poultry.
Priorities, after all, are everything.
You really have to admire the institution's ability to compartmentalize. The government might be completely gridlocked, but they will not rest until that swamp turkey gets its day.
That's Floor Notes full session for today.
Thanks for navigating the record with us, everyone. Take care of yourselves, and we'll catch you on the next episode.